It's time to resume, and we've already formed a quorum. Ellen, you have a short question, and then it's Leung Sing's turn. Yes, Chairman, as you agree, what we are talking about the profit surplus plowback requirement, it just exists in name. I think the crux of the matter is, as pointed out by the Chairman in the report, the grantee are the parent organization of the hospital rather than the hospital itself. And as you can see from the report, from para 3.13, it's pointed out that as the grantee is not the hospital, is the related organization, and as a result is able to invest in whatever way it likes, and is not subject to the profit surplus plowback requirement. I would have thought that if the administration had been doing its job in monitoring the work of the hospital, and I was asking about Table 2, and that's precisely about this point. And as you can see, for Hospital C, originally it did not possess the two sites itself. So the sites were held by the related organization. Subsequently, this was changed, and at least we know who to go after. So we are able to pin down Hospital C, and we are able now to discuss with Hospital C about this. So I was asking about Hospital C. All right, you managed to change it so that it's now changed to the hospital itself instead of the related organization. But then how about Hospital B, D, and F? So it's Land Grant 2, Land Grant 6, and Land Grant 8. And yet the DH did not do the same, so that it would be changed back to Hospital B, D, and F. I was referring to F. B, D, and F. I'm referring to hospitals B, D, and F. So LG2, LG6, and LG8. How come the administration did not ask them to do the same as what it did to Hospital C, so that the land grant would be changed back to, or the grantee would be changed back to Hospital C? Bureau Director or Director? So is the way forward. Director, well, is for the organization itself to apply for it. Chairman, well, the change was initiated by the hospital itself. It was not us that took the initiative to ask it to change it. Well, I understand this is a difficulty, but then whatever or whoever the grantee is, whether it's the hospital or the operating organization, the DH would always ask for the accounts, and we will check how it used the surplus or profit. But then the initiative is on you, because it's you who grant the site to the grantee. Ellen, can you explain a bit more about your question? Well, I think the Bureau Director understands what I mean, but then I think the administration is saying that, well, for Hospital C, it was not initiated by the administration. But then my question is, well, after this audit, I think the picture is now clear. I think the crux of the matter is on this. Because in doing the auditing work, when you ask the auditors to do the certification, all right, the situation is so confused. All right, one site is privately owned, one is land grant with conditions, the other one does not have this condition. So when they hold the land in the name of the related organization, that's why we have the situation as the audit found out. Alright, some $300 million plus was paid to the grantee as usage fee. But then if the site is held by the hospital itself, like Hospital D, then it would not be that easy to manipulate or maneuver. At least you would have found it more easy or easier to trace back or track it. But then on this occasion, they've used the parent organization to hold the land. So would you agree that this is a critical loophole? Because if you agree that this is a critical loophole, then my question just now was, why did you not take action to plug this loophole? If Mr. Leung is asking about how we can take the matter forward, I agree that in the future, when the operating right, whether it's in whole or in part, given to a third party, we will have to be consulted. Ellen? All right. When you are if you're consulted, you might allow them to do so. But then I'd like to know more about the policy and how it should be interpreted, all right, if they really ask you in the future. What criteria would you adopt in deciding whether or not you would allow them to give the operating right to a third party? Then what would you do? What would you say? All right, the thing is about the operating right of the hospital. Well, when I look at it, if it's about the core business of the hospital, then I would be inclined to not allowing it to give it to a third party to operate. But then if certain hospitals outsource certain services, we will have to look at it on a case-by-case basis. If certain hospital is to outsource, say, security services or asset management or property management services to a third party, then I think it would be okay. For example, the operation of a canteen. Well, Director for Lands, can you look at it from the Lands Department's perspective for grant conditions and also grantees' responsibilities? You're supposed to enforce the land lease and the land grant conditions. How would you view it? All right, that's a question raised by Mr. Leung. So can you give us some advice? Chairman, when it comes to enforcing the lease, the most important thing is the grantee. All right, whoever is given the operating right, the grantee will have to be held ultimately responsible. That's why very often the land grant conditions would say that you are not allowed to sublet, and if you were to sublet, you will have to have the prior approval from the administration. That's to ensure that, all right, if it's going to sublet, well, it's not that it's not allowed, but then there is a mechanism in place to ensure that the administration will be able to see if that would result in the grantee not having any control over the site, because the most important thing for us is, well, being a grantee, you have to be responsible for whatever happens on the site. That's from the enforcement of the land grant conditions perspective. All right, can you then explain how this can be resolved, Bureau Director? First of all, I agree with Ms. Lin, the Lands Director, that whether it's the hospital is operated through a third party, ultimately it's the grantee that will be held responsible. And as I just said, well, they can consult us, and obviously I have to have the final or ultimate power. For example, one of the hospitals in question, if it has reasonable grounds for outsourcing a certain part of its operation to another operator, then in individual cases we might find it acceptable. Yes, Alan? If you have no further questions, then Mr. Leung Sing, can I ask Mr. Paul Chair to ask questions first, because he has not asked any questions yet this morning. Yes, I have a flu today, but I'll still be able to ask questions. Yes, please speak up. Yes, I think it's common sense. All right, if a unit is led to a tenant if he's to sublet it, then if he has not have my approval, then basically it's against the tenancy agreement, and I can always terminate the contract. Is that right? And I've also noted your answers. Apparently you're very agreeable. You will try to agree with what members suggest in their questions, but then I also noticed that, of course, it's not your fault, but then the only thing that you can do is to say that, well, I can only say what I'm going to do in the future, but then actually we're looking back, we're looking at what has happened, and what's more important, we'd like to find out the root of the problem. And what's even more important is to see if somebody should be held responsible. You've said that you'll be tightening this up, and in the future that will not happen again. But then let's look at 3 facts. Number 1, you should have checked the grantees to make sure that when they impose certain license, when they give any license fees to any third party, you have not done anything at all until August 2011 when you asked the questions. And the second thing that you have not done is, well, up to March 2012, only then you asked them about their previous donations. And the third thing that you have not done, that is until May 2012, you never asked them as to whether such donations were legally proper. So you only asked about the propriety of such donations in May 2012. And of course that's in response to the audit's work. That's good. But then for so many years, the hospitals have been granted the land at new cost, and they've been able to do whatever they want. So I think it's not fair to the taxpayers. So is there anything that you can do to ask them to pay it back? Well, on the first part as to what they have done and was that adequate, and the second part is about is there anything or anything remedial that we can do? Well, whatever they have done, whether they have outsourced certain parts of their operation to a third party, the only thing that we can do is to go after the grantee, and the DH is now doing something with regard to the areas that have been identified by the audit, that for certain profits that have been transferred to a third party, we are actually going after the hospitals for the accounts, and most of them have come back, and we are now analyzing the data. Yes, Director. Yes, the DH was starting from 2012 began to ask for the auditor's certification for the details. We are actually analyzing them. We are actually asking the grantees, in particular if the grantees are not the same as the hospital, then we would be asking them for further details, and we have asked the grantee to provide us with the relevant revenue and expenditure of the hospital in question. And after we have completed our work, if we find that they have not complied with the land grant conditions, then we will follow up on that. Mr. Chair, well, for how many years of accounts would you be asking under the law? How long can we go back? Well, since 96-97, so they have already submitted all the accounts since 96-97. All right, starting from 96-97, all the accounts have been submitted to you. Well, since the new lease has come into effect. All right, allow me to ask further questions, Chairman, because this is forward-looking. If you have indeed found out that there have been non-compliances or even breach of the law, in other words, for the grantee, if the profit has been siphoned off, whether intentionally or unintentionally, and as a result that might have been a breach of the land grant conditions, then what would you consider to do? What would you do? All right, this is a question that has not been brought up by the report. All right, Paul has asked this question, and you have the right to answer and the right to not to answer, but then whatever you say, you'll be held responsible for it. So you have to think carefully about it. I do have the responsibility to remind you of that as to what you're going to do, because on the 18th, I'm sure at the panel meeting, you would also be asked this question. But then I'm just reminding you of what we're supposed to do under report number 59. Thank you, Chairman, for your reminding. Yes, we will follow up on that. But then as to the way we will go up, as to how we go about it, that will depend on the actual circumstances. So I'm not in a position to answer your question right now because we haven't yet have any idea as to what those circumstances are. All right, they've paid some license fees and so on. We understand that they've actually sublet some of the places to a third party. So what are you going to do then? We have also noticed that's why, as you have noticed, well, the entire hospital or part of the operating right might have been given to a third party. And as I've made it clear, that is in the future, all these will have to have our approval in advance. And in making the approval, I would also have to go by certain principles. For example, if it's the core services of the hospital, that would not be allowed. But then for some support services, there is a possibility that we might approve it. I would also like to add one point, that is looking back. Well, some hospitals have given us an explanation, explaining why for some of the specialized departments, because the hospital itself does not have that expertise. That's why they will have to work in partnership with some external sources. So from the angle of the hospital's operation, we understand their practice. Director, with regard to subletting, we are actually checking the accounts, and also for the revenue from the subletting, that would also be viewed as or deemed as the revenue of the hospital, and therefore we will be looking at it from this perspective. And also where there is subletting, we will ask the hospital in question to apply to apply for approval from the Lands Department, and in some cases the Lands Department has already processed those applications. Mr. Chair, I understand what you said. That is, if the hospital does not have enough forward-looking or technicality or technical expertise, then it might have to outsource part of its operations to a third party. But then if you look at the monitoring angle and also the responsibility angle and also the monitoring of how the profits are used, apparently the DH has not done its job for so many years. So my question is, all right, for these centers that are still in operation, or other than tracing back to what it has done and who the responsibility should lie, where the responsibilities should lie, should we take it as a fait accompli? And as this is like the unauthorized building works of the chief executive, so should we treat this as a fait accompli, and therefore you cannot but accept it? Is that part of your practice? Well, attitude-wise, of course, that's not true, because as you have heard from the director, a lot of follow-up work is taking place. But then can you provide us with some papers as to what you've been doing, so that we will have an idea as to what you're doing? Mr. Paul Chair, I think I'll stop here. Mr. Ng Lang Sing, and then after Mr. Ng Lang Sing is Mr. Raymond Wong's turn. Thank you, Chairman. I would like to get more information about the land grant conditions. It's about the profit surplus plowback requirement. That's 3.12, no, 3.13. You talk about the so-called license arrangement, so between the hospital and the third party. There will be this agreement, and if you're not able to make sure that there is full compliance, then public interest might be compromised. In other words, the profits would not be plowed back in the hospital services provided by the hospital. So there is inadequate monitoring or inadequacy on the part of the DH. All right. From the angle of monitoring how the profits are distributed, can we do something about it? So by just relying on the auditor's report, will that be adequate in monitoring the use of the profit? And also when the profit is plowed back for reinvestment, are you sure that it can be done? Because this is rather technical.
You should be able to see in what items, medical items, the hospitals have been investing. And have you tried to differentiate hospitals with good performance and those with poor performance? If you have done so, can you provide us with the information? Otherwise, it's once again proved that the requirement has not been adequately enforced. As for the degree of transparency of distribution, have you made sure that the grantees had adopted a high degree of transparency? Secretary? Mr. Chairman, as we said, even the service providers under the grantees had to submit report to us. Director? Mr. Chairman, the audited accounts or financial reports had to be submitted by both the grantees and the service providers under them. And we've asked them for the reports, and the reports have already been received. As regards poor performance and good performance, we're still handling the cases. We may not have any broad brush conclusion for all hospitals or grantees. So that actually supports the audit's conclusion that the plowback requirement has not been duly enforced. After all, this is a gatekeeper job for the public. The grantees or hospitals' proceeds are in real money. Now, I'd like to ask something about the handling of donation. Mr. Tse did say that the DH did not make inquiries to the hospitals about the details of the donations. Well, up to March 2012, that is early this year, there have not been any such inquiry, and some of the donations were actually in huge sums. Any reasons for that, Director? In the past, in the course of renewal, we did receive audited accounts from the auditors, and we did not look at the breakdowns. That's why previously we did not inquire about the breakdowns. Do you have the power to regulate their accounting work? Well, does 311 empower you to do so? I think you should answer Mr. Ng's question in terms of land grants. Yes, Mr. Chairman, we also look at the requirements and conditions in the land grants. Well, the items are different for different hospitals. In some cases, there's no restriction on donations. In some of the cases, the donations are not to be used for religious or evangelical purposes. If that is the case, to rectify the situation, I'd like to ask you, for huge sums of donations, would you carry out monitoring afterwards so that the donations would not be channeled to the pockets of private individuals or private companies? Secretary? Well, for sure, we'll do that. We've actually asked them for all the accounts, which we're now analyzing. All right, then I will jump to page 35 of the Chinese version. That is donations made by private hospitals. For Hospital B, 31.2% owned by the hospital operate within its hospital premises. That is almost 70% fall outside hospital premises. So if you do not do your monitoring work well, a huge proportion will be public premium subsidizing private land grants. Can I have some responses from you? So for Hospital B, have there been loopholes? Director? Mr. Chairman, for this hospital, the hospital does have shares in the company, but not the grantee. We are now analyzing the materials to see whether there's any plowback. We've already received the information. In other words, in the last 6 years, there were 3 times of dividend distribution. So you look into whether or not those dividends had gone into private pockets. And you're going to look at how proceeds are distributed. Well, we'll see whether the proceeds were plowed back into the hospital. Director, we're following up on that case. Leung Sing, would you please provide us with follow-up information? Because even after writing our report, we'll continue to follow up on the issue. Well, this case indicates that you need to adopt rectification measures. May I refer you to 3.13F, submission of draft accounts. I'd like to look into this practice. In urging for the submission of audited accounts within a reasonable time frame, I can see some information here, and I'd like to have your testimony. It said that some copies of certain accounts were not submitted after a certain period of time. So any guidelines here, any time frame? I think you should at least give them a time frame. And in general, do you have certified copies of these audited accounts? Director, Mr. Chairman, due to time constraint, a provisional copy certified by the auditor should be submitted. Well, the honourable member was asking about 3.13F. They submitted the certified copies afterwards. Leung Sing? Well, after the closing day, in what time frame should they submit a certified account or copy? Well, we did not specify a time frame, but they've already submitted the certified copy. All right, Yukman, Mr. Chairman, I'd like to follow up on a minor issue. That is about the proceeds surplus plowback requirement. As many colleagues said, time is limited. I will move on to another topic after this follow-up question. Well, as the monitoring body for private hospitals, I think the DH has not played its monitoring role adequately. The DH did not ask the Lands Department to clarify from the grantees, hospitals, associated companies, etc., to see whether or not the handling of the donations were in order. The Director of Lands should answer this question. That's their responsibility. Director of Lands, as I explained to members last time, for PTGs, after their granting, for those conditions related to hospital services, we would like the relevant policy bureaus and departments to follow up, because they have more contact with the hospitals. So they should follow up first. If unsatisfactory situations are discovered and follow-up action is required, then the Lands Department will follow up. Well, that's where the problem lies. You think they can do it, and they think you should do it. Well, this is land grant. It's not hospital affairs. For hospital affairs, they're more familiar and you can ask them. But this is land matters. Land matters. I have to put on record that the Lands Department is absolutely responsible. Director, I've never said that the Lands Department does not have the responsibility. What I said was that among bureaus and departments, there should be a division of work. And on this, there must be consensus. It must not be ambiguous. So in future, for the monitoring and division of work of the PTGs, I'd like the administration to clarify. And all along, we've been partners. I've no intention to say that the Lands Department has no responsibility. Well, Mr. Chairman, in the course of this hearing, members came to know of some information, and you did not know the information either. Well, the audit, of course, should detect problems before they emerge. The same applies to you. I think both your department and the audit should be able to detect situations that should have been detected. Now, the audit saw this, you also saw it, but then you did not follow up, you did not make improvements. And now the audit tells you that you did not make improvement. Now, this hearing indicates that the audit has more foresight, but not you. We as members are to pursue these matters, of course. For 3.13c, we have hospital-related services. They are mostly provided by related companies on hospital premises under PTGs. So the services are provided in the hospital. But whenever the related service companies involve PTGs, the matter becomes very complicated because the proceeds will not be included in the hospital's profits or surplus. So I'd like to ask this, for complicated situations like these related companies under PTGs, should there be more monitoring? Secretary? I agree. For more than once just now, I pointed out that we should have a mechanism to regulate the grantees. That means if services or partial services are provided by the grantees under the name of related companies, they should seek approval first. Are you on 3.16? Yes, 3.16. Site development not strictly in accordance with the land grant conditions. I think in the afternoon, the session that Paul is to chair will take quite some time, so I'll try to be more concise. In 3.21, it's pointed out that in 2006, Hospital C proceeded to redevelop the premises on LG4, but thereafter, there's no longer any elderly center and a day hospital with rehabilitation facilities. Well, up to mid-August 2012, it was not discovered that the social center for the elderly and the day hospital with rehabilitation facilities were no longer available. So that's only discovered in 2012. During those 6 years, is it really true that you did not detect the problem? That is, starting from 2006 up to 2012. In those 6 years, is it that you did not detect this problem until mid-August this year, when the audit report was released and the audit investigation was completed? Because in the investigation process, you were consulted. Well, on Yuk Man's question, I have to remind members that we've got a new supplementary document, R59/4/Gen 3. Table today? Which document, Mr. Chairman? R59/4/Gen 2, not 3, 2. I just want to remind members that we had received that paper. Have members got that paper? If not, please give them a copy. Secretary, before you answer, I just want to remind members that the hospital had offered us the supplementary paper. Director, have you read their paper? Yes. Mr. Chairman, in implementing the grant, we based our investigation on the grant in June 2006. The grant should be granted on the conditions then.
Center for the elderly and a day hospital with such clinics, rehabilitation facilities and other facilities as may be approved by the Director of Health. 咁嘅過程呢，醫院嗰啲營運嘅醫療相關嘅項目呢，衛生署。
So for medical related items, the DH did look into the condition and we did enforce the grant. And the services were to be provided in the hospital. As for the elderly center, that comes under the Social Welfare Department. Yuk Man, well, in 3.25, we see that the Lands Department has approved the building plan. But then up to early September 2012, none of the building plans, with the first plan submitted in November 2007, had been approved by the Lands Department under the land grant conditions. In November 2007, here it is said that the first plan was submitted. As the director said, there was no communication among the various departments. Now, the building was commissioned in 2008, but it's only in September 2012 that it is discovered that the building plans had not been approved by the Lands Department. Can we have some explanation on this phenomenon? The two government departments operated independently with no communication at all. Director, can you explain this? Lands Department, Buildings Department, and the HD, they operate independently. Yuk Man, let me finish. They have to explain to me first before addressing your concern. Well, they have to tell us what the system is. Well, Mr. Chairman, I was about to come to this, but then you acted earlier than I. My question is, why could they have allowed a hospital to start operating without building plans being approved? Yes, this is an overall problem about responsibilities. Please explain. Thank you, Mr. Chairman. Indeed, the Buildings Department and the Lands Department studied building plans separately. In the process, we have communication, but then the standpoints are different. The buildings department will examine whether or not the building plans satisfy all the requirements in the building's ordinance, and the safety provisions are very important. So before each development commences, for example, before the hospital is redeveloped, it must have approved building plans from the buildings department before works should commence.
The lands department will vet the plan as well. And before work commenced, we will have to deal with compliance under the plans. Everything required will have to be submitted, say for example, locations of ingress, egress, operation of the various centers. Are they reflected in the plan? In terms of safety requirements, everything was in order. They've got approval from the buildings department, but I admit that when work commenced, they still haven't got approval from us, and that itself is undesirable. It was in 2005, not 2007. Preliminary plans were submitted to the lands department. At the same time, the department was dealing with them. A lease modification on the same lot. It's the construction of a connecting bridge. It's also mentioned in the land grant. And there are also some height restrictions. So lease modification was in progress. When we found the record and worked out why it was done this way, in 2005 the plans were submitted. But could the plans be approved at that time? That depends on the lease modification in relation to the construction of the connecting bridge and the height restriction. So there are different parts. Over a number of years, the plan was not actively followed up, and that was what we could work out. But I am not saying that I am not making excuses. There are inadequacies. These things can proceed in tandem. On one hand, the lease modification will be dealt with, and on the other hand, the plans could have been vetted on a preliminary basis, but that wasn't done. Mr. Wong also asked, when we came to know that the elderly center was missing. It wasn't when the audit report was released at the end of 2008 and beginning of 2009, when the plan was being reviewed. Plans of the elderly center, the social center for the elderly, seemed to be missing. Therefore, in 2009, inquiries were made from the person in charge of the private hospital. They were asked to make out on the plan where is the social center for the elderly, where is the hospital, and where is the day hospital with rehabilitation facilities. And it wasn't until 2011, the latter half of the year, when we received a proper set of plans with demarcations. And as soon as it's received, we liaised with the Social Welfare Center, who oversaw the Social Center for the Elderly, and the Department of Health, to see if everything was in order. And that is undesirable, but that is how things panned out, and I give the information to you in a chronological order. So in relation to the site development not strictly in accordance with land grant conditions, LG4 all the incompliances. I think that that is the dereliction of duty related to the Department of Health and the Lands Department. I want to record it that the Lands Department and the Department of Health will as soon as possible rectify the non-compliance under LG4, and you need to reconsider stipulating under LG4 the minimum number of beds provided and whether that is suitable. My next question is about leasing. Well, give him a chance to answer. That's only fair. Would you like to answer? There is a certificate of compliance. It's issued by you. You have to take that into account. Mr. Wong's point is related to the issuance of compliance and related matters. Can you look into it? In 2011, when we received a set of plans, it is easily seen the various facilities. This is not related to CC, so that is the occupation permit. Members of the public listening following the meeting will not know these acronyms. CC is compliance certificate and OP is occupation permit. We are aware that the private hospital has submitted a document to the PAC, to the Public Accounts Committee. Looking forward, they told us when the social center for the elderly was given back because it's operating in a different location. Were it not for the audit report, it could very well have never existed and will never exist. This brings us to another problem, that it's a systemic one, that the requirements will have to be followed up, will have to be complied with, monitoring will have to be done, because we're talking about public funds. Mr. Wong, I am now going to move on subleasing of hospital premises, 3.34. In relation to Organization E, there is a breach of the no subleasing requirement. The premises of the hospital were subleased. The Lands Department was aware of that, but the Lands Department condoned that, and that was a serious dereliction of duty. It was only in July 2012, in relation to the renewal of the temporary waiver, there was no further progress. How do you explain that? I would like to hear from the director. Director, can you give us an explanation? Yeah, there was no condoning on the part of the department. It was back in 1993. Well, starting from 1993, the hospital regularly applied for a waiver. So an area of the hospital premises is subleased to a non-profit making organization, so that is done officially. What about the waiver? It expired in 2005, and there was no progress as at July 2012. But there is a time period specified in each waiver. Can you explain to us in response to Mr. Wong's question so that we know what went on? The first waiver, well, you will find it on page 43 in the Chinese version. That is page 49 of the English version. Some background information is provided by the audit. As I said, the hospital followed the procedure and applied for the waiver from time to time. since we saw that it's being subleased to the same non-profit making organization for operation, and no rental was charged, so we allowed that subleasing and gave the waiver. When it expired and when a renewal was applied, let me focus on the last occasion when it has taken a long time. When we were dealing with the application, what we saw was the subleasing to a non-profit making organization, and at the same time we saw that there seemed to be some medical centers operating there. We want to seriously enforce the lease conditions, so we have to clarify, because previously when it was subleased to a non-profit making organization, that was in order. But as to whether the non-profit making organization was illegally subleasing the premises to other centers, we will have to find out, and it took time. We try to find out if there is any irregularities on the first layer, that is, when the grantees sublease the premises to the non-profit making organization. That on the face of it seemed to be proper, but during the renewal we want to clarify certain matters, and they have to clarify. That's why it's taken time. It's not the case that we condone that. So what are you going to do in the future? If I remember it right, there are 7 medical centers or medical organizations there. And we've spent some time to look at the last one to get some clarifications. And we have confirmed that there was no further subleasing by the non-profit making organization, and we agreed to approve the waiver for the grantee to sublease the premises to the first profit or non-profit making organization, and it would start from the expiry date of the last waiver. Can you give us the documentation so that we can incorporate it into our report? 3.35, the Audit Commission's recommendations. It says that the Lands Department needs to rectify the situation on LG7, including seeking the approval of IXCO in accordance with the lease condition if required. Director, can you give us a reply? When it comes to lease modification, if it's just a sell and purchase in the market or land grant, the Lands Department is authorized to deal with that. But when it comes to private treaty grants, we have to look at the original agreement to see if it was approved by the IXCO, or whether the IXCO has authorized the relevant policy bureau to give the approval. When it comes to such private treaty grants, the IXCO earlier on, that is in 1960s, authorized the relevant policy bureau to give the approval. And as a result, amendments, in relation to amendments, we will first seek support from the policy bureau, and if that is obtained, we will proceed with the amendment or the modification. Director, when the Audit Commission was carrying out the investigation, did you give the same explanation to them? If you have, the report will not be worded in this way. So we wonder whether there was any communication between you two. You're talking about a change in policy in 1966 by the IXCO. We would like to get some information, because if that is shown to the Audit Commission, they would not have made this recommendation. If you show the Audit Commission more document, then you wouldn't be wasting our time or wasting the Audit Commission's time for them to try to track the relevant evidence. Mr. Wong. Thank you for the elaboration. I share the same view. I'd like to say that the director on this occasion has been very clear with her answers. When the audit spotted the irregularities, I'm afraid the answers were not as clear to the audit as she did and as she gave it today. So, Chairman, you are indeed very wise. Mr. Gary Chan. Just a simple follow-up on 2 points. I'd like to get some clarification from the administration. 3.24 Hospital C. In November 2004, the Lands Department issued a provisional basic term offer for a proposed lease modification, and it's taken 6.5 years when it was executed in March 2011, and it's unacceptable. The lease modification has yet to be completed. How can the new block, the works of the new block commence? That is my first point. Shall we deal with the first point first? Sorry, it's a point of order, Chairman. I was reminded by Paul. And very often when we're asking questions, we got lost. Well, you mentioned about the answer. The answer given in reply to all these inquiries, but the director was not Ms. Lin. Yes, I understand, but there are documents. Perhaps we can now turn to Mr. Chan's questions. Director. I think before lease modification was completed or plans was approved, work commenced, and that itself was not proper. The risks will have to be fully borne by the grantee. In the end, if the lease modification was not approved or the plans were not approved, we have the right to ask for the building to be demolished, and that will not be desirable. And in relation to the lease modification in paragraph 3.24 and why it's taken so long, the lease modification relates to the construction of a connecting bridge and the relaxation of a building height restriction. When the application was first made, it was only in relation to the connecting bridge. But the bridge has to be connected to something, and will require amendments to be made on the 2 ends of the bridge. And we found that the preliminary plan of the connecting bridge was not approved by the then building authority. So that it wasn't efficient, and that's why it's taken so long. There are some technical issues and also issues related to efficiency. What about the second part of the question? Say, if it's not a hospital block, there is another block that has sprouted up. They may be penalized. They will be asked to demolish the block. In relation to Buildings Department and the Buildings Authority, and in relation to the non-approval of plans, can you give us more information in this regard, the approval of plans? The Buildings Authority, in other words, the Buildings Department, has yet to approve the plan, so it would be difficult for us to proceed with the lease modification, and everything was intertwined. May I further elaborate that in the case of a residential block, this situation would not have occurred. That is, when the building has been completed, the plans have yet to be approved. Because when it comes to a residential block, they will need a certificate of compliance, and it will only be issued after all the requirements have been met, and it was only then that they can sell the flats.
They will have to ensure that the plans have been approved before they can carry out the works, but then in this regard they have not done it. Well, it shows precisely that this case also involved different departments other than the lands department. It might have involved the buildings department and also the SWD, and therefore in dealing with such complicated cases, will there be a dedicated department which will be responsible for processing the application? In other words, there is a leading department or a coordinating department. Is that such a department in this case? And if they just deal with their own business, then we may have a situation like this happen. I understand that at present there are some departments which might have some reservation about the plans, or if they have other comments, then how come the business department can just take the lead and suggest that, approval will be given and you can go ahead with the works? Why does it have to be so hasty? In any case, it's not the responsible government or the sponsoring department. So the buildings department is not here. Which department can answer on its behalf? And if you don't want to answer, then it's okay. We can write to the buildings department. Well, Chairman, I'd like to clarify. You're talking about approving or giving approval for different things. Earlier on, when I answered the question with regard to the buildings authority issuing works permit for them to start the works, it's about the daycare center and also the day hospital. So it's about the plans for those facilities. But then here we are talking about the buildings department saying that there are some problems. It's the connecting bridge. But then it's easy to have misunderstanding because it's on the same site. But then it's at different times. It's about different plans. And therefore you will have to explain the situation to them, because they might have treated it as one whole thing. So, yes, the footbridge and everything else is different. And therefore they will have to be dealt with separately. So you should explain that clearly to them. But then what about the whole works? Is there any leading department? Was there any leading department, Thomas? Yes, Chairman, I can supplement. As the Director of Lands just said, we would look at the buildings plans and also the land lease, and those would be dealt with in two parts. And as the Director for Lands just said, in terms of the land lease, there were certain considerations, but then with regard to the building plans, the BA, the Buildings Authority, would follow the Buildings Ordinance in processing the application, and there would also be certain time limits and procedures that he will have to follow. For example, in order to make sure that the building plans would be in line with the requirement, there are also certain statutory requirements that he will have to follow. And the current requirement is for the buildings department to play the coordinating role, so that all the building plans will have to be passed on to the relevant departments for the approval process. Mr. Gary Chen. Yes, I finished with this, Chairman. I'd like to then turn to the issue of subleasing of the premises of the hospital. 3.32 says that the Bureau and the DH already indicated that they are not against subleasing of certain facilities in order to provide certain services, but then certain waivers will have to be obtained, and the lease will also have to be modified in order to regulate the situation. According to the Bureau Director, in some private hospitals, is he aware of how common this is as a practice for private hospitals to sublease their premises, and do you agree with the DH practice? Do you think that this is in line with the current land grant arrangements, and when will you be able to complete the regularization exercise? Bureau Director and then the Director. I'd like to clarify with you. Are you referring to all private hospitals? 3.36. Can you refer to 3.36? Can you ask that again, Mr. Chen? Well, para 3.36, the final part. The report says this. Nonetheless, the FHB indicated in its memorandum of August 2001 to the Lands Department that while it had no objection to the subletting of premises in Hospital E, the breach of the land lease should not be permitted to continue, and a new waiver or lease modification to regularize the subletting was essential. So can you respond to this? Well, our attitude is that on the one hand, we understand that well, in some cases, some hospitals might need to set up some medical service centers, but then for one reason or another, they might need to hire external or outside experts, and therefore they might have to engage a third party to help it so that it can be involved in the operation. So we can accept this. But then if that's viewed as a breach of the land grant condition, either we disapprove it or we will require it to seek a waiver or lease modification. All right, Director, any supplement? Well, Chairman, on this particular case, as I've already said it, well, for the final area that is not clear, we have already clarified with it. That's why we have agreed to issue the waiver with retrospective effect. But that part of my question is also related to this, because the report only refers to E. But then my question was how common this practice was. Does the Bureau Director or Director of Health have any information about this? We do not have all the figures concerning the private hospitals, but then we have already written to all private hospitals, and also during the annual inspection exercise, we have already asked these hospitals if they have such operations, and we have already reminded them that they will have to comply with the land grant conditions, and if they have such operations, then they will have to notify the Lands Department, because it's for the Lands Department to follow up. We have already notified all the private hospitals of this. All right, we can ask till 1 o'clock. So we will have to end this part by 1. All right, Ellen? Thank you, Chairman. Well, the main thrust of this part is that if you have such conditions, how are they being implemented and how do you monitor it? So it's about the profit surplus plowback requirement and also the subleasing. Well, on both areas, we are not satisfied with what has happened so far. For the free beds, well, apparently nothing has been done about it. And for the low-cost beds, well, as we took evidence, we could also see that it's barely satisfactory, and much is left to be desired. And also with regard to the plowback requirement, as has been said, for the hospitals profits, well, there are several ways to reduce it. Donation, well, they would donate it, or they can also pay rents. And in some cases, it's license fees, and then they can also pay that. And also it's been paid to some related organizations, and as a result, they've also paid it to some related organizations. All right. According to the Bureau and the Department, they are trying to look forward, and therefore they are trying to make amends. And therefore, for the previous omissions, they are trying to remedy the situation as far as possible. But then I'd like to ask this, in concluding this part. Just now we have heard the Director of Lands who said that well, in September or October, she already sought legal advice, and then for individual hospital, it was sitting on two sides. On one side, we had the two salient point requirements, and on the other there is no such requirement. Then what should they do? Should they be segregating the two sides? So can you also tell us, have you sought legal advice on the other issues? For example, say 3.38, you also refer to this. Private hospitals, running certain services like a hospital. And 3.14, are you also seeking legal advice on that? Say if they have given certain donations, or license fees, or usage fees, and so on. So what can be done about it? So what's the scope of your seeking of legal advice? And also, do you have a timetable that you can tell us roughly when you would be able to take some remedial measures to remedy the situation? And thirdly, what do you have in mind to remedy the situation? So what does it include? Well, there are two bureaus here. One is headed by Dr. Koh, and the Secretary for the Development is not here. So can you answer the questions first, Dr. Koh? Well, on this particular part, as we have already pointed out earlier on, the DH already asked all private hospitals for third-party operators and the accounts involved. So we have already obtained all the data, and we are analyzing them. And where necessary, we will seek legal advice. Director or Secretary for Development, I'll ask the Director of Lands to answer the question. Yes, Chairman, as Dr. Koh just said, well, the legal advice will have to be based on the facts and also the information that we obtain from the grantee consent. And therefore, once the DH has come up with the analysis, we will try to coordinate with them. All right? So it's difficult for you to give us a timetable, right? So do you have a target of completing everything within 2 years or 3 years? So do you have a work target, Bureau Director? Well, as far as my bureau is concerned, we haven't set any target yet, but then I might need 2 or 3 years. Well, I think at most 3 years. But then I think we all understand that it's a very complex matter. But then without a timetable, without a target, then it would be difficult for you to make sure that you'll be able to complete it on time. So yes, we will be looking forward, and if you're going to set a timetable of 3 years, then you will have to come up with the targets, what you plan to achieve, and then we will be able to follow up, as the Chairman just pointed out, to all the witnesses. That is, even after we have completed our scrutiny of report number 59, it doesn't mean the end is. It doesn't mean that it's the end of the story. We will continue to follow up on this. So can you give us an idea as to what difficulties you've encountered, and which direction you're taking in collecting the papers, so that we will have an idea. All right, we'll give you a reply in writing. Okay? Does the Development Bureau wish to supplement? No. So you will follow up after they have done their work or done their part. So do you have a timetable? How long will it take? On land lease issues, usually we will follow the land administration process, and it's for the Lands Department and also the relevant bureaus and departments to follow up. Paul, do you have any questions? It's a very short one. Apparently, building a basement is a very small issue, but then building a whole hospital is okay, even if it's unauthorized. Well, but then if it's owned by private individuals, it's a separate matter. But then since it's your personal opinion, I'll try to answer it personally. But then it also involves private interest, other than seeking legal advice on land administration, and also things that are related to hospital management. Do you plan to submit the relevant files and documents to the Inner Revenue Department to see if they need to go after certain party for tax that have not paid? I think they're also the experts, so please do not wait till after the 3 years before you take action. So have you considered that? Bureau Director, is a suggestion. Well, the only thing that I can say is that according to my understanding, the IRD has been independently discharging its duties under the law. Paul? I understand that for Tony Chan, the IRD has taken immediate follow-up action. But then, in major cases like these, they should have taken the initiative to do it. But then, would you also be referring the cases to them? Well, in the process of scrutinizing the documents, well, I have to say that if we find out that it involves other pieces of legislation, that there might be breaches, and of course, we will refer the cases to the relevant departments. Yes, that's also part of what we're going to do, as so that we can be forward-looking. Mr. Alan Lau, I have two short questions on the development. All right. We have the new hospital questionnaire. We also have the new inspection checklist, focusing on land grant conditions, whether they have been consistently complied with. Okay, with this new mechanism in place, according to the Director of Health, and it's been in place for several months now. So during this period of time, have you found out that there have been any breaches or non-compliance under the new questionnaire and new checklist? Have you identified new problems, or have you identified any problems, Director? We are looking at some accounts. We are looking at some breakdowns and details. So we are in the process of checking the accounts. But then other than that, do you have any information that shows that there might have been non-compliances and so on? And also in terms of the enforcement, have you encountered any difficulties? Because after all, this is a new system. That is the checklist and also the questionnaire. It's been in operation for several months. Have you encountered any problems? Well, for the low-cost beds, we still adopt the 20% ratio. For the 20 free beds, the hospital has already submitted its proposal as to how the 20 free beds can be implemented. All right, with the new system in place, can we reasonably expect that you will have to seek the Lands Department's help, and there might be a higher probability that you will need it to help? Or is it that, well, because you have a new questionnaire and you also have the new checklist, and therefore for the inspection staff, they will be looking at the land grant conditions in carrying out their inspections. And we've also heard from Ms. Lin during the first hearing. She explained the whole flow chart. All right, for the frontline officers, they would have to know it, and they will have to do it in a timely and appropriate manner to seek assistance from the Lands Department. So can I reasonably expect that with regard to the seeking of help from the Lands Department, the number of cases will increase? So the two directors. Bureau Director. Well, I believe that at present, as it now stands, the connection or the communication between the two departments is already very close. But then the assumption is correct. That is, if we are going to do a more detailed job in our monitoring of the hospitals, then I think Mr. Leung's estimate is correct, because there will be more areas that we will have to clarify. I was just asking this as a question, but then I'm of the view that after this auditing exercise, if the two departments do not communicate more closely and cooperate more closely so that they can join hands in enforcing the law, then I would find it most disappointing. Yes, on behalf of all the parties concerned, I can say that that's for sure. All right, thank you. Okay, so we will now adjourn and we'll come back at 2:30, and then we'll move on to part 4. All right, let's deal with part 4 when we come back again. Thank you.